A parliamentary inquiry is now underway into reforming Australia's race hate laws. A joint committee is examining the operation of the Racial Discrimination Act and the way in which the Human Rights Commission handles complaints under Section 18C of the Act. The inquiry's first hearing yesterday featured yet another skirmish between coalition senators and the Commission President, Gillian Triggs. Well, Liberal Senator James Paterson is a committee member and an ardent supporter of changing 18C. Senator James Paterson, good morning.
Thank you for having me, Hamish.
Let's start with free speech. Parliament's Human Rights Committee has begun its inquiry into Section 18C. Of course, for anyone that doesn't remember, it makes it an offence to offend, insult, humiliate or intimidate a person based on their race. Now, the government has a majority of members on this committee. Is it a foregone conclusion? What do you think should happen?
Well, the government does have a majority on the committee, but the government members on the committee have a range of points of view, from people like myself, who are strong advocates of change, to people like my colleague Julian Lisa from New South Wales, who's in favour of some change, but certainly not as far change as I'm seeking.
So what would you like to see? Scrapping of it altogether?
Well, I think at the end of the day, the only thing that will guarantee that we don't have any more cases like the Queensland University of Technology students case is scrapping it altogether. But I recognise that, first of all, there is no path through the Parliament for a total repeal bill. That just will not pass the Senate. And secondly, when this reform was contemplated previously in 2014, a lot of communities said that they felt that scrapping 18C altogether would make them feel unsafe in the community. Okay. And no one wants them to feel that way.
Just tease this out for me. Why repeal it altogether?
Well, because if the law isn't there, then the law can't be used. So the QUT case could never have happened if the law wasn't there. And in addition to that, there are a lot of state laws which I think much better target the kind of racial abuse that we hear from time to time occurring on public transport.
Tell us what the logical argument is for repealing it. The QUT case is one thing, but that alone is not your argument against 18C, is it?
No, it's not. I think the Bill Leak case is extremely concerning as well. I'm pleased that it appears to not be proceeding, but it's not proceeding because of the law has been a great protection of free speech. It's not proceeding because the applicants in the case have changed their mind and decided that they didn't want to proceed with it.
Again, can I just tease out, what are the principles? Why do you want to see it repealed?
Well, freedom of speech is one of the most fundamental things about living in a liberal democracy. And if there are things that we can't talk about, that we can't write about, that we can't debate because it may offend or insult someone, for example, then I think we've lost something. We've lost something really important.
I noticed that there is this 58-page submission from the Institute of Public Affairs to the Commission calling for its repeal. What's the difference in that report and your position on this?
I don't think there's much difference in our positions. As you may know, I previously worked at the Institute of Public Affairs before I was elected to the Senate in March. But my view is that a more realistic path forward than a total repeal is just deleting the words offend and insult. And that's a private senator's bill, which is currently before the Senate, which has about 20 co-sponsors from the Liberal and National parties and also the crossbench.
Would you accept that some people might be cynical about that, given that, as you point out, you used to work for the IPA? There's not much difference between their position and yours.
Oh, people may be cynical, but I'm certainly not the only advocate of change. As I said, there are 20 senators who've co-sponsored a bill. I'm the only one who previously worked at the IPA. Certainly it's a principle very important to the IPA, but it's a very important principle to the Liberal Party, and there are a lot of Liberals who feel very strongly about this, as I do.
Why are protections against race hate speech so problematic for you?
Well, they're problematic because it's been shown on a number of occasions, and the Bolt case is another example of this, that public debate is being impinged by this particular law. Now, I'm not saying there should be no protections against it. At the state level, in fact, at every state, there are criminal provisions which prevent people from engaging in racial abuse, and I think they better target the kind of vilification that we want to prevent in the community, whereas they don't impact as much on public debate as 18C has.
Why is that?
Well, because they're better targeted. They're more narrowly targeted. They are targeted at what is really harassment and stalking and actual intimidation, whereas 18C covers things like offend and insult.
So what are the things you should be able to say?
Well, you should be able to, as a student at the Queensland University of Technology, to say on Facebook that you've just been kicked out of the unsigned Indigenous Computer Lab. That's what one of the students said, and then his punishment for doing that was a 3.5 legal ordeal.
But we both know, though, that there is more to it than this. I mean, there's a pretty broad spectrum of stuff that you could be able to say if you remove insult and offend, right?
Well, that's one example. Another example is you should be able to draw a cartoon without being hauled before the Human Rights Commission and demanded to explain why your cartoon is not racist.
Sure, but the question is about what this unleashes, right? That's the concern that people have, that if you remove those words, it gives licence to a whole bunch of other stuff that is more than a cartoon, more than a Facebook post.
Well, what I'm seeking to protect is freedom of speech in public debate. People contesting.
Would you acknowledge that point, though? Would you acknowledge that point, that this would open up something much broader than just that cartoon and that Facebook post?
Well, if you're only removing offend and insult and you're keeping humiliate and intimidate, which is the main proposal that is before us and what I'm advocating, then you would still have pretty strict restrictions on what can and can't be said. And there would still be lots of scope to take action if people felt something was really beyond the pale and not just spirited debate, which may offend some people, may insult some people, but which I still think is important in a liberal democracy.
You won't acknowledge, though, that a lot more will be available to people to use and say in the public space if those words are removed?
Well, no, because there are other things which are restricting on this, including the state laws I mentioned, and also including, the good taste of the Australian people and the media. We can push back against people who say...
You rely on the good taste of the Australian public and media? I mean, there's a lot of people that would say that, we do push things too far.
Well, that might not be your view, it might not be the ABC's view, but yes, it is my view. I think
don't reflect anyone's view. I'm just asking whether that's sort of the standard accepted in the community.
Absolutely. Australia is one of the most tolerant, open, free societies on the planet. We abhor racism, we abhor abuse, and we call it out. There are many examples of this. I think one of the really good examples is the Eddie Betts case earlier this year, where a woman in the crowd threw a banana at Eddie Betts and said some awful things about him. She was immediately called out, roundly condemned, apologised within a week, and Eddie Betts said he was satisfied with that process. So that didn't require 18C, it didn't require the Human Rights Commission. It just relied on the good nature of the Australian people, and I think that's a good example.
But as you point out, this is a matter of kind of good faith. These laws don't apply to comments that are made, to quote, in reasonably good faith, in the pursuit of art, science, academia or the public interest. Section D of this Act ensures that. Why is that not of any use to you?
I'm glad you mentioned that because I think 18D is a really inadequate protection of free speech. Most famously, we've seen this in the Andrew Bolt case. Most people, when they talk about the Andrew Bolt case, say Andrew Bolt wasn't eligible for free speech because he made errors in his newspaper article and therefore was found not to engage in good faith. That's true, but that's only half the answer. He did make errors. But in addition to that, the judge in that case, Morty Bromberg, found that he wasn't eligible to use 18D free speech protections because he, quote, the tone of his article. And that includes the fact that he used sarcasm, that he used gratuitous asides, and that he wrote things between the lines. So in Australia in the 21st century, if a judge doesn't like your tone, you are not eligible for free speech.
But that's exactly what you're talking about, though. If there's a perception that the tone is wrong, then, people will assume it's not made in good faith. So isn't that the same point you're making in defence of the alternative?
What I'm proposing is that the Australian people and the media and others call it out, not that the law and the courts prevent people from saying it in the first place.
So you want the sort of the court of public faith?
Exactly right.
Okay. The inquiry is also looking at the complaints handling procedures by the Human Rights Commission. The committee recalled Gillian Triggs yesterday to discuss the Queensland QUT case. She declined to answer your questions. Why don't you accept her explanation that the matter could be sub judice, given that there may be an appeal?
Well, if it was sub judice, then it was also sub judice last month when she went on the 7:30 report and discussed the case in some detail with Lee Sales. Now, yesterday when I asked her about the inconsistency of being happy to answer questions about it to Lee Sales but unhappy to answer it to a parliamentary inquiry, she firstly said that it was not her intention to talk about it when she went on Lee Sales' program, and then later she said that she went on Lee Sales' program and she talked about it because there had been many misleading things said about the case and the Commission, and that she thought it was appropriate to defend the Commission and to correct the record. So those two things are inconsistent. Either she had no intention of going on and talking about it, or she did have an intention of going on and talking about it to defend the Commission. They can't both be right.
And so are you happy for her to see out her term, or would you like her to go before the end of it?
Well, she's up in, I think, about the middle of next year. I've said for many years I think that she has failed in her duty to uphold all human rights, including things like freedom of speech and religious liberty and property rights. So for that reason, I'd be very happy to see her go and replaced as soon as possible.
And who would you have someone in mind?
No, I don't have anyone in mind, but I'm sure there'll be many good applicants.
All right. Senator James Paterson, thanks for your time this morning. We appreciate it.
Thank you, Hamish.
It is 14 minutes to 8. You're listening to RN Breakfast.